G'day, Monnette.
Hi, Andrew.
You got the short straw.
That's it.
Yeah,
How you going?
performing with me. How dangerous is that?
Yeah.
We've just finished doing a podcast. Our verdict is our emerging or challenging new law that's coming out. So in the next few days, the verdict will be out dealing with Victorian psychological hazards and codes. So we'll let you know about that. But it's been fun doing that, and I've been working with Monnette and Nim and Nina to try and get all the stuff for you. So I think it's really good. Today, actually, we're going to talk about restructuring, and I think probably one of the things that concerns me greatly as it arises, and it repeatedly arises, is that when women are on parental leave, suddenly their job disappears and people seek to restructure. And I thought it'd be just good to have a recent case, have a look at the law, but also morally have a think about if we're not dealing too well with somebody before they go on parental leave, shouldn't we address it then? Should we not look for an opportunity that arises while they're away having children and then try and think of restructuring and redundancy? So that's our topic today. I know it's a bit confrontational, but it's one that I think we just see too often and the risks are too high in. And I think as employers, we do respect our talent, man, woman, however someone assigns themselves, but we see this far too often occurring. Yeah. But why don't we jump into what is our first one, which is the new anti-bullying regime, which is a regime that's grown up in New South Wales. And it's an interesting regime because it only attaches to the public sector, so they're the only people. But this is our first regime where we've seen bullying be monetarised in a legislative regime. In other words, you can get damages up to $100,000. You can get penalties as an organisation up to 90 plus thousand. I think around about 20 for individuals. And it has all the stop orders and everything that sits within the Fair Work Commission. But I'm raising it, I think both you and I are really interested in this because I think this is the beginning of a new jurisdiction which is going to insert itself into every state and territory. And I don't know why it's there, is the short answer. We've got common law dealing with damages, so why is it there? We've got safety legislation that punishes breaches of safety law. It's sort of hard to know why it's happening, and I can't see why it is other than New South Wales thinking it wants to do something different. Okay. You got any thoughts on it, or are you just going to look at me and go, no, you just stole everything I was going to say? Is that what you're going to say?
No, I had that all written down.
Did you? That's good to see. Monnette, what can I say to you about the franchising world? In the franchising world, as you know, it is criminal to underpay people. Franchisors enjoy a similar relationship to employers under the legislation. But we've got this fantastic new Baker's Delight case that has come out, and Sean McElwain is the judge in the federal court. And the case is interesting because as a point of law, it was elevated to the federal court, the full federal court, to look at what is this presumption of responsibility. And in Baker's Delight, this was a franchisor which had three franchisees beneath it, which were Baker's Delights. And there was an underpayment of something in the vicinity of $600,000 or something like that. Is that correct?
It was 1.25.
1.25
million, but then Baker's Delight would have been responsible for half of that.
Yeah, and the franchisors became insolvent and they were wound up, but they would have been responsible for the others. But the question is the franchisor, that is the person who owned the effective licence for these three Baker's Delight stores, who had to act in accordance with their direction, could they be liable with the same presumptions about their knowledge and responsibility as the franchisee? And unquestionably, what the full federal court said is, yes, they are. And in franchise land, that's pretty scary, really, because what that means is, as a franchisor, you have a level of control that sits under the franchising code of the quality of the product, the manner in which you run the business. But it means you must have an auditable process that you can assess from time to time. You must have strict rules around what is lawful payment, because the criminality that sits there can also lead to individual liability, which can lead to jail. So this case is probably one of the real turning points from franchise. Remember, franchising law created criminal wage theft through the 7-11 cases, so it changed the law. But here we're seeing a case reflecting on the intention and saying, no, a franchisor will be criminally liable for underpayments, and there are things that they can do. So when we talked about what they can do, They can do audits. What are the other types of things that franchisors could do?
They can strengthen compliance systems.
Yep.
Whether they, I don't know if this is possible, have more insight into the record keeping and actually access
No, they
those.
can. They can interrogate. And if you look at, I've acted for franchisors and franchisees, they set up the bookkeeping method that the franchisee is obliged to do. They would normally have access to it because they take a percentage of gross earnings or net earnings, depending on the rule. So what this says is, you set up this arm's length business as a franchisee. You set up the systems that sit behind it. You can't ignore your knowledge of what will happen, because that franchisee, to make money, given their limited capacity to make money, and you're going to take some of that money off the table, the only way they can make more money is what? It's actually pay people less. So it is a system that leverages underpayment, and that's why franchisors will be liable. So fascinating case. And look, for the franchisors and franchisees out there, we're going to send out a newsletter on that for you so you know about it. But I thought we'd talk about it now because the obligations of a franchisor are, of course, exactly the same as the obligations of an employer. Okay, why don't we move on to our next case? And I guess, isn't it funny? We regularly talk about what happens around gender bias. We see all sorts, the evidence is sadly compelling that all women by the age of 40 have experienced some form of sexual harassment. Over 10% of women, I think it's around about 12% of women in any 1 year of their work will experience some form of sexual harassment, negative or positive. So when we think of gender-based bias, we're inclined to think of the really bad end of the scale, aren't we? That you're treated badly in a sexualised manner. But gender bias can be a whole range of things. And when we're talking about Holman Toll Transport, we're talking about a case where a woman said, look, I was treated differently as a result of a woman. I got bad shifts. What are the facts of it? Tell me more about the facts of it.
So she said she was sexually harassed. She was given the worst jobs. She wasn't offered the country jobs because the males in the company said that she was not, or females shouldn't be doing that side of work. Denied career progression. So, yeah.
So look, can I say this was really for me? I can remember when I started cooking in a restaurant a long time ago, and occasionally I'd go out and I'd work waiting. I do all the introductions because men introduce people to the tables, not women, okay? I might remove the plates, but when it came to cleaning up afterwards, that was always the women's job. Gender-based bias is perceptual, commonly unconscious bias. Now, this woman didn't succeed in the end because there was an investigation that occurred in the process and didn't demonstrate that she was being treated differently. What was the final decision in it?
So
because this was a case, isn't it? This was a case where she brought a claim.
Yeah.
And there was a jurisdictional argument because what she said is, I was forced to resign as a result of what was occurring. And when the court looked into it, they said, no, there's a number of different things you could have done if this was occurring.
Yeah, so she didn't keep very specific details about what had happened. No reference dates, no details. So that made it a little bit hard.
Yeah, so there's two things here. The court said you didn't have to resign. You could have gone off and got an order to stop what was occurring in the stop bullying or stop sexual harassment. So that's one of the things. But secondly, your allegations lacked sufficient particulars to be a proper allegation that could be investigated because it failed to identify dates, time, places, etc. So an interesting case, isn't it? Because I don't doubt that inside the facts of this case, which we will never see, that this woman probably did suffer from time to time gender bias, but she failed to appropriately document it was and to remedy it through taking the actions she ought to take. Instead of that, like so many women would do, she walked away and said, it's not safe for me, I can't work here. Yeah. Interesting, isn't it? If it was a guy, he would have stayed and fight. If we take the classic stereotype of man versus woman, I'm not saying the man would have. I'm just saying, isn't that the final straw, that the woman felt that she was so disempowered by what occurred that she felt she had to resign? And isn't that the ultimate pain of gender bias? Anyway, I want to talk to you about a general protections claim that failed, even though there was a level of success in it. So this is Clark and Vortex. Can you talk to me a bit about the facts in Clark and Vortex?
Yeah, so this guy submitted a general protections claim. He made some complaints regarding the health of his team via email, but in doing so, he didn't, seek any relief or redress or raise any form of grievance.
So this is going to our workplace right, okay? So when we look at a general protections claim, you have to be treated adversely as a result of exercising a workplace right. But the narration of a series of events is not agitating a workplace right. It's not saying, I need this to stop. It's not taking a stand in relation to a workplace right such as safety and saying this needs to stop. In doing that, I'm exercising a workplace right. This person wasn't exercising a workplace right. They were narrating an event. And it's quite different, isn't it? So, Monnette, when we look at Clark and Vortex, it was funny. Champion, who's the judge, said, well, there was underpayment, so that part of it was proven. But when he looked at the argument that there was a workplace right being exercised, he found two things. One is the person who raised this, the applicant in this case who was dismissed, they weren't raising it as a workplace right. They were nearly narrating a series of circumstances. And in any event, the test is the subjective mind of the decision maker. There was no evidence that those issues were elements in the subjective mind of the decision maker at the time, and therefore the claim failed. And can I just say, general protections claims fail all the time. Hardly any ever get up, even though there is a reverse onus, which once Monnette raises the issue that Andrew's treating you adversely, the responsibility goes to me. It's still a very hard jurisdiction to win in. So I think it's an interesting case, and I think we both talked about it. It's a complex case as well, isn't it? Why don't we talk about the rejection of a psychological claim in a FORIO, an Australian Capital Territory? And again, this is another one of those cases which is not easy because we're talking about the workers' comp jurisdiction here. And we're talking about what happens when there's rumours, when people gossip about people. Now, we know they're psychological hazards, okay? So tell me the facts of this case.
Yeah, so this was a nurse who brought a workers' comp claim because of the physical and psychological
and physical. Don't forget the woman running into her with a walker.
Yeah, so she had
she won on that, by the way. She won on the physical claim from patient's mum going, meh.
Yeah, exactly. Bruised, soft tissue injury. So she raised it with her seniors, but they didn't do anything about it. Even her colleagues didn't know that she had suffered this sort of injury. And so, yeah, she submitted the claim, and for the physical injury, she got 8 weeks of payment because that's how long it took for her to recover. But from a psych point of view, that was rejected, that claim, and essentially it was brought down to the fact that she had a pre-existing mental health condition.
So can you see how important this is? You know, when people work for you, the idea in Victoria and Queensland, you can actually ask under the workers' comp legislation, do you have any pre-existing element that may impact your capacity to undertake the inherent requirements of your job? It doesn't have to be in every other workers' comp jurisdiction because discrimination law would allow you to ask that question. But the issue here is, and so often the issue in workers' compensation, is people's response to an incident. Did the incident cause the psychological problem, or was the psychological problem present? Okay, here they're saying this was just a pre-existing psychological claim. It was not triggered by an event, it was a pre-existing psychological claim, therefore it's not compensable. But if work was a substantial cause of that psychological problem, it would be compensable. So a neat little case, I've got to tell you, because once again, this is the hard end of workers' compensation, actually trying to pair apart when it is and when it's not. Monnette, Chowdhury case and ISS security is a really interesting case, okay? This is where a person alleged there'd been some rumours around their performance and behaviour. They said that it psychologically affected them. They've been bullied, harassed, defamed. A detailed investigation was undertaken. The investigation found that wasn't a proper basis for it and the claim was rejected. But what I want to talk about is we do need to be careful about gossiping. You know, we stopped drinks. I was just chatting to Tom earlier today. We stopped drinks as a firm on a regular basis because people started to line up with the silos of who they worked and gossiped about other people. So we stopped it because it hurt people. Don't worry, we'll be coming back, but we stopped it for a while just to give people a break and reflect on what's right. But I do want you to understand when people gossip, they create risk for others. Now, in this case, the investigation found that it wasn't part of the causative chain for the problem that arose. So in Chowdhury's case, it shows a good investigation will clean up where there's problems. But I don't want anyone to lose track of the fact that when you allow people to gossip, and humans gossip because that's the way they connect with the world and determine who's powerful, and not tribally, we need to do gossiping, but there's good gossip, working out how an organisation works. HR is gossip after all. And then there's bad gossip, which is destructive and hurtful, and that would breach all values and should be stamped out. Because if you do it long enough, you will harm someone. Here's a case where an investigation revealed there wasn't the causative chain, but I got this case really just to say gossip is bad.
Yep.
Okay. Can we move on to our main topic, which is restructuring, particularly employees on parental leave? We've got a case called Kelly Dieball and Brookfield, where we don't know exactly what happened. Brookfield eventually released a statement saying that they're going to go back and retrain and be more careful. But I guess you and I too often see cases of women who are 30 weeks out after child suddenly receiving a note that says, look, your job's been taken over by a number of people, there's no longer a job, we want to talk to you about redundancy. And what I can say to you is there are three key elements here. Let's go to element 3. 20 years ago, restructuring a business to get rid of a person who's on parental leave would not have had any reputational damage at all. Now it is massive, to the extent that Brookfield published a letter to everybody to say, we got it wrong.
Yeah.
So does that show you how powerful reputational in social media times, how dangerous it is? The second thing is, the law requires you to act flexibly in bringing people back to work who are on parental leave, to be mindful of their capacity to do it and to look for suitable duties. That's a statutory obligation. That's actually got to be your lens, not can I get rid of this person? And of course, the first thing is any person who seeks to work flexibly and has a statutory right to flexibility, I must consider what that is. And I should not be dealing with old issues like I don't think this person performs, I don't think this person is capable. That should have been dealt with a long time ago. And if it's being dealt with now, it's far too late. But I come back to the last part. If you were on parental leave and I was a co-worker and I heard you got shafted on parental leave, I would not like my employer. But it happens all the time. So I just want you to think as employers out there, what do you think when you do that? People think about you? And the answer is, everyone goes, gee, if you're going to pick on someone as vulnerable as that because they've got a child, I don't like you. Yeah. And that's what social media says every single time. And that's why Brookfield published a letter putting their hand up and saying we can do better. Yeah. Why don't we go and have a look at the case study, okay? Right. Interesting case study today, because I drafted it. Much shorter, but let's have a go.
All right, so Mick was a bit rough around the edges. He had worked as an apparel buyer for Hot Stuff Online, a brand retailer for women aged 21 to 35. His career began at Myer when he was 17. Now, at 40, he lost his athleticism and looks. Hot Stuff was owned by Steph Glitter, a well-known Sydney influencer and startup model. Mogul. Her warehouse in Collingwood was staffed by 20-something private school girls. Mix thought they had attitude, and Steph wanted them to have attitude. It was the brand. Clementine, head of sales, and Ingrid, the ICT manager, really didn't like Mick, and the feeling was mutual. They had cultivated complaints about him. Several women came forward saying that they didn't feel safe and that he was uncouth and that he sexualised them in conversation. Clementine spoke to Steph, who arranged for her barrister brother, Nigel, to investigate. Nigel obtained covert recordings of Mick's conversations at a local bar. From these recordings, he captured key lines such as, "She's hot, I wouldn't say no," and others. The recordings were benign if listened to in context. However, he rolled them into omnibus complaints about how Mick interacted with women, alleging that he sexualised them and that he understandably felt unsafe.
He felt quite safe.
They underfunded.
Yeah. Come on, stay with me.
The complaint did not disclose the lines. They came from a covert recording. Nigel had no intention of advising Mick about the recordings. Nigel approached Mick and asked him to come to Steph's office for a show cause meeting with Steph present. Mick was given an opportunity to read the complaint. At the end, he stood up and said, "I'm not sticking around for a kangaroo court. You don't say when, who, what happened, or where this conversation is alleged to have taken place. This is bullying and nonsense, and I don't feel safe." He went home and drafted a simple letter saying he was shocked, hurt, and felt very scared to return to work. The following morning, Steph read his emails, spoke to Nigel, and they responded by accepting his repudiation of employment, stating that his refusal to participate in an investigation amounted to a breach of lawful and reasonable direction. They further said he had now abandoned his employment and they accepted his repudiation.
All right, so let's go to the questions. Did his refusal to come to work amount to abandonment? No. He must show a deliberate intention not to return to work. Mm-hmm. He didn't feel it was safe, therefore that would fail. Were there problems with the investigation process and what was the legal effect? Mm-hmm. The investigation was deeply flawed. Mm-hmm. The Ansett baggage handler's case says you must put all evidence for a person so that they can properly respond. The selective use of evidence, of course, is fatal because it didn't align with the truth in the allegation. And finally, an omnibus allegation is a rolled up allegation without any particularity. A person to be able to respond must know the date at which something occurred, where it happened, what happened and who with. None of that was possible. This is a flawed investigation and would fail at every level. What claim under the Fair Work Act? Well, he's got every one you can have. So he's got unfair dismissal and general protections claim, and both would be successful. Mm-hmm. It's fun doing this, isn't it? Nice and quick. Yeah. Was there a breach of safety law? And if so, whom and what would happen? So there was a number of breaches of safety law, but there is a discrimination breach under safety law. He raised a safety issue and was terminated because of it. Mm-hmm. He's got an argument on that. There is fundamental primary duty breaches in relation to the risks he was put under by the process, and we're seeing that process litigated in a number of different environments, and what's left in the VBA case is directly on point. So there's safety breaches at an individual and at a corporate level. Does he have a common law psychological claim based on breach of contract? This is Alicia and Vision Australia. Mm-hmm. The answer is yes. The process was flawed and it caused harm, so yes. He's not doing too bad. He's got a lot of claims, hasn't he? Would he have a valid workers' compensation claim based on the flawed investigation? The answer is yes, 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 yes. So there you are. We're done. We are done and we are out of here. Well done, Monnette.
Yeah, thank you.
Thumbs up. Cheers.